Deputy Knock, I ask you to move the amendment.
Thank you, and I move the amendments. Just before the clock starts, I just want to recognise Caherley retired Garda Sergeant John Hines and his wife Catherine, who are in the gallery this evening. John is probably one of the foremost members of An Garda Síochána in terms of securing prosecutions against sex offenders right across the west of Ireland. In fact, 26 of the 28 cases that he brought to the Central Criminal Court secured convictions. 27 of those 28 cases involved the late Detective Garda Colm Harkin and Garda Maeve Carty, who is still within the force. So if I can talk to the amendments that I have here before me, and specifically to Amendments 2, 4 and 5, which address the issue in legislation where there is a requirement for a sex offender who has been put on the sex offenders register to notify the divisional headquarters. The reality is that divisional headquarters are spread right across this country. Take, for example, the divisional headquarters for my own area, for Longford, Roscommon and Mayo. It's located in Castlebar in County Mayo. So for someone living in Longford, Roscommon or Mayo, the nearest location for them to register is Castlebar. The legislation states that a sex offender can inform any divisional headquarters in the country. And one could have a situation where someone who is convicted of a very serious offence is considered to be a high-risk sex offender and, say, resides in Roscommon or Galway, notifies Wexford Town Garda station. The person that would have to comply with this legislation as currently drafted would have complied with the legislation as currently drafted by doing so. My amendment states that such persons must present themselves to the nearest public office of An Garda Síochána, preferably to the local 24-hour operating station. And let us remember that it is the local Garda in the local area who will be responsible for monitoring these sex offenders. We are not even asking the sex offenders, in order to comply with the register, to present themselves at the local Garda station where they are going to be monitored. And Minister, I believe that this is wrong. This is facilitating high-risk sex offenders going undetected by allowing them to contact any divisional headquarters. This comes on the back of what I believe is a culture concerning the overall thrust of much of the legislation in this area, which puts the rights into the hands of the offender rather than the victim or the future potential victims of these individuals concerned. So, Minister, what I want to see is the legislation clearly reflecting a responsibility on a sex offender to register at their local Garda station. As you know, presently, the register is there in name only, and every year in excess of 70 breaches are recorded of that register. These involve individuals who have come to the attention of the Gardaí, usually for some other reason, and then they're prosecuted for a breach of the sex offenders register. We need to put a robust system in place that facilitates the Gardaí in monitoring these individuals, and that can only happen if the Gardaí are given the tools to do that. Now, you will recall, Minister, when I raised this issue with you at committee stage, you said the inclusion of any, in terms of any divisional headquarters, was to capture a situation where the sex offender to be monitored may be away from their local station, but that the intention of the legislation was to ensure that they would register at the local Garda station. And you said that you would consider making it clearer in the legislation. That hasn't happened in relation to the legislation that stands here before us. And we do need to see that clarity provided in the legislation. Now, in your letter to me, Minister, of the 28th of September, you point out that where a sex offender does not register at the local Garda station, where they register at another Garda station, something as significant as a change of address would lead to an automatic email emanating to notify all persons who have access to the sex offenders' details on the Pulse system. Now, the difficulty is, Minister, that a high-risk sex offender who is released from prison calls into a Garda station in Wexford Town, giving the address in a rural townland in the west of Ireland. And you can rest assured that we're supposed to rest assured because an email is being sent to the Garda stations across the country that this individual has registered in Wexford Town. But the problem is that it's the Garda based in Castlebar that has to make contact with this individual, has to try and track them down and trace them within 7 days, have them fingerprinted, have them photographed. And the difficulty is that the system does not allow that to happen. Because the difficulty is, Minister, even if that member of the force isn't on holidays or on leave, even if the member of the force gets access to that information, the likelihood is that they have to sift through literally hundreds of these updates, activity report updates that come in relation to every single sex offender across the country. So on a daily basis, volumes of these activity reports come into every single Garda in the country that is dealing and monitoring sex offenders, and they have to sift through all of those to find someone who has recently registered in another divisional headquarters who is now going to reside in their area, identify that, track them down and have all of that done within 7 days. Minister, we are asking too much. We are giving too much power to sex offenders who want to remain underground, who want to remain undetected. And the only way to put an effective system in place is to legally oblige a convicted sex offender who requires monitoring to present themselves at the local Garda station rather than a Garda station at the other end of the country. And I would urge you, Minister, to accept the amendments that I tabled to reflect that.
Thank you, Deputy Naughton. Any other deputies offering on these 5 amendments? I'll ask the Minister in that case to respond.
I'll speak to amendments 2, 4, 5 and 6 and then move my own amendment 3 if that's okay, because it's grouped together. Deputy, as you've outlined, the bill provides that a sex offender can notify at any Garda station that has been designated by the Garda Commissioner for the purpose or any divisional headquarters. What we're doing here is not limiting essentially the offender notifying at his or her local station, and by drafting the provision in the way that we have drafted it, a sex offender who regularly resides in Cork but who might just by chance be in Donegal for 3 days, it means that they can notify and will notify the Garda in Donegal that he or she is in the area. Can I just reassure the Deputy that the way we have set this out has been in consultation with the Gardaí. So if an offender notifies at a different station to which they would normally be residing, the information is reported on the Pulse system. It's not only available to be viewed nationally, but in cases where there's a court change made to an offender's details, so for example a change of address where it's not just that they're visiting, an automatic email will notify all persons who have access to the sex offender's details on the Pulse system, including the sex offenders management and the intelligence unit. The Commissioner himself will obviously designate the various different stations throughout the country at which a sex offender can notify, and this will be published on the Garda website. So what we've set out here has been in consultation with the Garda Commissioner. It's not to restrict where a person can register themselves. It's to try and make sure that if a person is moving or if they are outside of their own home place or where they are designated, that they can still register, even if it is, I suppose, if they are moving only for a short period of time. Compliance in this area is high, so there's nothing to suggest of the figures that are applying this section that there is a significant amount of non-compliance. Compliance is still high, so everything that we have set out here has been, as I said, with the consultation of An Garda Síochána, that they feel it will operate and it will support the work that they are doing, and that Gardaí will have access to this change and this information via the Pulse system, which I think is the correct way to do it. Thank you. Separately, amendment number 3. This provision allows for a member from Garda Síochána not below the rank of inspector to change the interval between notifications for offenders who do not have a permanent home address. The purpose of this amendment, which I had flagged at committee stage previously, is to allow a member from Garda Síochána of any rank to inform the offender that their interval between notifications has been changed. The decision to actually change the notification will still have to be taken by a member that's not below the rank of inspector. So I just want to move amendment number 3 as well.
Minister, I'm disappointed with your response in relation to an issue which I believe is fundamental to this particular bill. And I know you're looking at this from a particular perspective. But if you turn it on its head and look at it from the opposite perspective, rather than looking at it and how it facilitates the sex offender and it's not limiting them to the local Garda station, what you are saying is to a convicted sex offender who has to be monitored, who needs to be monitored, who poses a high risk in the community, you can go to any Garda station in the country. You can present yourself to that Garda station and say, you can go to Wexford Town and say that you're going to live in rural West Roscommon. You've complied with the law. The difficulty is, it is the Garda in Roscommon that has 7 days from that point in time to try and track down that individual, have them present themselves in the Garda station in Castlebar, provide their fingerprints and photographs. This is a mechanism to ensure that sex offenders remain underground, those that deliberately want to remain underground. What we need, what we must have in the legislation is a legal requirement that the sex offender must attend their local Garda station when registering, not some far-flung location at some other point around the country, when it is the local Garda who is responsible for monitoring this individual. Now, for you, Minister, to say that everything is okay, because if they go to Wexford Town to register, an activity report on the pulse system is circulated to every single Garda in the country that is monitoring sex offenders. These Gardaí get hundreds of these notifications. You're asking them to sift through those hundreds and identify a new individual that has moved into their area, who is trying to remain underground and who is trying to conceal his identity so that he won't be monitored.
Firstly, what I would say is we're not doing this to facilitate sex offenders. We're doing this to make sure that we have a system that works, whereby that they can continue to be monitored. This has been carefully written out, this has been carefully thought through, and as I gave a commitment at committee stage to look at this and to respond back to you, having engaged again with the Gardaí on this, they are happy and they are clear that this is the appropriate way to approach this specific part of the bill. And I think it's important that we take on board their requests and their requirements in this regard, how it will work best for the people that you've just outlined, that have to actually monitor, that have to engage and have to make this work. The compliance at the moment is high. It can always be better. Any non-compliance is not a situation we want to find ourselves in when we're talking about sex offenders, but it's about making sure we have a system that works, and that in particular works for the Gardaí, the people who are going to be monitoring the sex offenders. So I have given a commitment and had given a commitment to look at this, but we have engaged again with the Gardaí on this, who are happy with how this has been set out. And I think for me, that is the appropriate route to take here, and that is why I can't accept this amendment. If it is a situation, and I give this commitment here, where this does not work, where, as you are suggesting, that it will allow people to go underground, to not be monitored, then I absolutely commit to reviewing this, to looking at this again, as we need to with any legislation if it's not working. But I have to go on the basis of what I'm being told will work for the people, as I've said, who are actually monitoring these sex offenders, and that is why we haven't changed it. That's why it is as it was set out in the committee stage, and that's unfortunately why I'm not going to accept the amendment. But I do accept, if issues arise, if there are significant concerns, and if the Gardaí come to me and say that they're having problems, that they can't access information, that it's meaning that people are going underground or whatever you want to say it, then obviously we will have to respond and act. But I think we need to give this a chance to obviously come into force first. Thank you.
Mr. Proposer, you can come in once more.
Yeah. Minister, 13 years ago, your department highlighted problems with the legislation today. It has taken us 13 years to get this far. Now, are you honestly telling me that when there is going to be a problem with this, that we're going to see amending legislation? We won't. Now, Minister, you're saying that the Gardaí are saying that they're happy with what's in here. Well, Minister, I'm 13 years at this, and I can tell you that the Gardaí around the country who are actually enforcing this at the moment are saying that this is a coach and four being driven through this scheme by having this flexibility built into it, because it will be used, it will be exploited. And Minister, compliance is not high in relation to it. There are 70 breaches a year identified by the Gardaí where sex offenders are not at the address that they actually have specified and listed. 70 a year on average is happening for the last 2 decades in relation to this, because the system as it is structured puts all the cards in the hands of the sex offender, has left the Gardaí in a situation that both of their hands have been tied behind their backs in relation to it. And we are now asking Gardaí in different parts of the country to try and track down these individuals and ensure that they comply with what is set out in this legislation, what is very worthily set out in this legislation, without them even knowing what they look like. Because as the legislation is written, a sex offender, in order to comply with the law, can present themselves in Wexford and then reside in Roscommon or Galway in the west of Ireland, in the most isolated part of that region, and it is the responsibility of the local Garda in the west of Ireland to try and figure out exactly where they live and ensure that they comply with the law without even knowing what they look like.